Good evening. My name is Chuck Iova, and I'll be presiding over this evening's Planning Board meeting, October 9th, 2019. First thing I'd like to do is read for everyone's benefit for those in attendance under the provisions of the open meeting law. Attendees are informed that this meeting is being recorded by MATV. I have not been notified that any other video or audio recording of this meeting will occur. Next thing we'll do is we will take a roll call. Let me get started here. A, B, C, G, F, G. Okay, go ahead, Mish. If we could start with Ken.
Ken Antonucci, Planning Board.
Diane Chuha, Planning Board.
Patrick Fitzgerald, Planning Board.
Tawaddash Gabrasilasi, Planning Board.
Thank you. Chuck Iovan, Planning Board.
Michelle Romero, City Planner.
Eric McCush, Planning Board.
Pat Hayes, Planning Board.
Eric Henry, Planning Board.
Henry Susi, Planning Board.
Charlie Ferguson, Planning Board.
Thank you very much. First item on the agenda this evening is 84 Linden Avenue. Is the petitioner present? Good evening.
Good evening, Mr. Chairman, members of the board. Patrick McDonald with offices at 477 Eastern Ave on behalf of the petitioner.
I might have to do one thing. Ken, did you read the announcement? Could you please read the announcement? Thank you.
The Malden Planning Board will hold a public hearing in the auditorium on the first floor of the John and Christina Markey Malden Senior Community Center, 7 Washington Street, Malden, Mass. at 7 p.m. on Wednesday, October 9th, 2019, tabled on September 11th, 2019, on the petition of Raymond Snow for a special permit under Section 700.1.3.1, Chapter 12, Revised Ordinances of 1991, as amended, of the City of Malden, seeking to allow the conversion of a pre-existing non-conforming property in the Residence B zoning district from a multifamily dwelling with 5 dwelling units to a multifamily dwelling with 8 dwelling units at the property known as and numbered 84 Linden Avenue, Malden, Mass., and also known by City of Malden Assessors Parcel ID number 050-282-211.
Thank you, Ken. Sorry about that, Councilor. You can proceed.
Thank you again, Mr. Chairman. Again, Patrick McDonald with offices at 477 Eastern Avenue on behalf of the petitioner, Raymond Snow. Just a brief note at the outset, Mr. Chairman. Mr. Snow's wife is ill today, and as a consequence, he has remained home to care for her. So he is not physically present, but obviously I am, and he does have his property manager. I hope that is sufficient for the board. To the extent they may have questions with respect to the petitioner, we can certainly do our best to answer them. As I'm sure the board's aware, we were before it approximately a month ago on the underlying petition, and the board voted to postpone and reschedule this matter in order that Commissioner Nelson, as well as the fire department, could have an opportunity to conduct an inspection of the property and report findings and make recommendations, if any, to the board. My understanding is that both the inspection has been accomplished and that the Commissioner and Fire Department's findings and recommendations have been submitted to the board. I can represent to the board that Commissioner Miller was kind enough to forward that to me. I've had an opportunity to go over those findings and recommendations with my client, and I would like to represent to the board that if the board is in fact inclined to grant the relief requested by the petitioner, the recommendations of both the building commissioner and the fire department are entirely acceptable to the petitioner, those being specifically that the building be sprinklered in accordance with applicable statute, that the existing fire alarm system be updated in accordance with current statute, that the what's been referred to as the 8th unit in the building, that being the basement apartment, be removed, and that some physical changes be made to a third-floor balcony area and egress area that the commissioner believes is not entirely safe. All of those are acceptable, and in that respect, I am suggesting to the board that although this petition was initially filed as a request for legalization of the subject property as an 8-unit residential dwelling, this petitioner is more than willing, as I said, to agree to the recommendation, and therefore would only be seeking legalization as a 7-unit family dwelling. I'd further suggest that, and as I argued at the initial hearing, that this is a property that appears, at least based on the commissioner's inspection of it, to have been constructed initially as a 7-unit family dwelling. It was approved almost 40 years ago at the time by the permit granting authority, the Board of Appeals, as a 7-unit dwelling, and through oversight or omission of a previous owner, that approval was not perfected by recording, but the property nevertheless has been used as a 7 for much of that period, as well as an 8 for some of it. And I don't believe respectfully that anything found by the building commissioner changes this property's compliance with the legal standard governing this board's decision, that being that the requested relief not be more detrimental to the neighborhood. As we suggested last month and suggest again tonight, that unlike most petitions that appear before this body, where the board has to engage in some speculation regarding the effect of any relief it might grant, I would respectfully suggest that this board doesn't need to engage in any speculation with respect to this particular petition, because again, it has the benefit of knowing that this property has been utilized as a 7-family residential structure for almost 4 decades at this point, and perhaps even longer than that, but certainly since the early 80s when the previous Board of Appeals variance was granted at that time. So we'd again ask the board to act favorably upon the petition and naturally available to address any new questions or concerns that may have been raised by virtue of the inspections that occurred recently. Thank you.
Thank you very much. Michelle, could you give us an update from your perspective, and then we'll go to Patrick because he's the one who made the motion for the inspection. So if you could give us an update on where we are.
Yes, so you opened the public hearing, received public testimony, and this was on September 11, 2019. You tabled the hearing in your decision with the requirement, 1, the petitioner provide additional information about the condition of the property, and 2, the petitioner allow access by the building commissioner to do an inspection specifically regarding the fire system violations, condition of exterior egress and water supply, to do an evaluation of the overall condition of the property and of compliance with conditions of the prior decision of the 1980 variance, and to provide recommendations to bring the property up to code, and for a rental unit inspection. That's all listed on the planning report and recommendation supplement. So that was what you voted on last month. Those were the specifics of your motion. So I did provide that information to the building commissioner and to the petitioner. The building commissioner, Nelson Miller, who's here tonight, if you have any questions about this, did conduct an inspection September 18th, 2019. And you have a copy of the letter that contains information about the inspection and recommendations. So that's dated September 24th, 2019. It looks like this. It has the 2 seals on the top, fire department and city building seal. Do you want me to read this into the record?
Yes,
or-
please.
Okay, so this is dated September 24th, 2019. It's addressed to the chairman. It reads, "The planning board requested that an inspection be performed of the property located at 84 Linden Avenue following its September 11th meeting. The purpose of the inspection was to confirm compliance with the previously issued variance as well as the overall condition and compliance of the property. The inspection was performed on September 18th, 2019, and was attended by Nelson Miller, Building Commissioner, Deputy Chief Leonard Halloran, and Captain Eric Diavola from the Malden Fire Department Fire Prevention Office, and the following constitutes our joint recommendations and observations of the property. The property currently consists of 8 dwelling units. The parcel contains a large parking area which currently accommodates all of the tenants. The basement unit, which was previously required to be removed, has not been removed. The remaining 7 dwelling units appear to be original to the initial construction of the structure. The overall condition and maintenance of the property is good with some necessary maintenance which would be expected of a house of this age. The inside of the property is pristine and well-preserved. The following actions are being requested. 1, the basement unit shall be removed in its entirety. The common laundry may remain for use by the tenants. 2, the entire building shall be protected by an automatic sprinkler system installed in compliance with 780 Code of Mass Regulations, the Massachusetts State Building Code, and NFPA 13. 3, the entire building shall be protected by a fire alarm system installed in compliance with 780 CMR, the Massachusetts State Building Code, and NFPA 13. And 4, the egress stairs and ladder access from the 3rd floor unit are to be removed in their entirety. The balcony outside the 3rd floor is to be evaluated for structural stability and repaired or removed accordingly. The owner must perform all of this work with the benefit of permits after a review by both departments. Please do not hesitate to contact us with any questions or concerns regarding this property. Sincerely, Kevin P. Finn, Fire Chief, and Nelson L. Miller, Jr., CBO Building Commissioner. I received this letter and sent a follow-up email to the Building Commissioner about the rental unit inspection because I didn't see that that had been covered in that letter. So by October 1st, 2019, I received an email from Nelson Miller, and it reads, "I spoke with Chris Webb, who's the Director of Public Health, prior to our inspection, and he did not feel that rental unit inspections were warranted at this time." That's from Nelson Miller. Chris Webb is, in his department, are the ones that administer the rental unit inspection ordinance. He was copied on that email. So those are the 2 pieces of information I received from city officials. Today, I believe, it was just today, I received an email from the petitioner that also contained information about the fire alarm system that's been in effect in the building. And I didn't print that for everybody, but it's a list of invoices and records of that system being maintained. Not the system that's being recommended, but a different fire alarm system. And the petitioner probably can speak more about that. So that's all the new information. So it's back before you. You did table the public hearing and your decision, so I think you will want to, and we did notify abutters again of this. So you
Okay.
want to do the public hearing part again as well.
Yep, Patrick, did this address your concerns that you raised, and anyone else who had any concerns that they didn't have enough information at the last meeting?
In part, there's a few questions that I have. Thank you, Mr. Chair, for the opportunity to clarify. There was reference at the last public hearing through the petitioner that he received some sort of document prior to purchasing the property that confirmed that the property had complied with the 1980 Planning Board order. The city planner had said that she had not received any such document. Are you able to confirm whether or not such a document exists?
If it existed at that time, Mr. Fitzgerald, my client was unable to find it. I don't know, I can't represent exactly to what document he may have been referring. Obviously, it was something that in his mind was sufficient, but ultimately we now know not controlling regarding the legal status of the property. I would, just to Ms. Romero's comment, I submitted about 20 years of records related to the payment by Mr. Snow for the fire alarm system that is currently in the building. I clarified when I sent it to Ms. Romero that it was not being offered to counter anything being recommended or suggested by the fire department relative to an upgrade or new fire alarm system, but merely to show that a fire alarm system had been in place for at least 20 years at this point and had been maintained through a third-party service. So that was the purpose of those materials. But they were nothing really more than a spreadsheet detailing the billing records and the payments by the petitioner for, again, almost a 20-year period. So the property has been in compliance in terms of having a fire alarm system in place for at least 20 years at this point in time, although it may not meet current ordinances or statutes regarding fire alarms, which is why, again, the petitioner is certainly agreeable to an upgrade if that is what would make the fire department feel better about any relief that might be granted here.
Understood, thank you. And I wonder if the building commissioner would be able to answer this. One of the conditions in 1980 was that an approved fire detection system be installed. I'm curious to know what type of fire detection system is currently there. Would it have been compliant with what was required in 1980 or any time more recently?
Yeah, the system that's there now appears to be something that would have been consistent with that era of alarm systems. It's a modern system as opposed to a ancient system that you see in some of our older buildings. So I would believe yes.
Okay. And the parking on the south side, would you consider that to have been sufficient to comply with the order from 1980?
It appears that way. Yeah, they have a very large parking area, and in speaking to a representative from the building, the tenants kind of coordinate where they park and who pulls in and who backs in and that kind of thing.
And were you able to determine whether or not the water supply was in compliance with the applicable code?
That's impossible for me to determine. That's something the sprinkler engineer would have to figure out.
Okay. And then the second means of egress from the third floor apartment, were you able to observe such?
I was. I actually walked out on it. It's not consistent with anything that you would expect relative to safety. It certainly doesn't comply with any codes. And on top of that, it's not necessary. That specific building, when you have 7 dwelling units, falls under a exemption in the building code where you don't need 2 egresses from every dwelling unit. That building is no different than a lot of the buildings around us right now, where all you need is a door to go to a hallway that gives you 2 means of egress. So my recommendation is, instead of having someone attempt to use that thing and get hurt trying to use it, I'd rather see it gone.
So you were able to say that the stairs and the ladder should definitely be removed, but you're not able to say whether or not the balcony itself needs to be? Yeah,
the balcony needs to be looked at by someone with either a CSL or an engineer. The balcony certainly can stay, but it's not a means of egress. It would just be somewhere to go out and sit and enjoy the night.
And you're saying that means of egress isn't required even today?
It's not.
Thank you.
Is that it, Patrick?
It is. Thank you.
Very good. Ken Antonucci.
Yeah, no, I'm sorry, Commissioner. Patrick, actually, Commissioner Miller answered it. About the third floor is not required, so thank you.
Very good. Eric Henry, please.
Thank you, Mr. Chair. Actually, for Mr. Miller, if he could, excuse me. I note here in your findings that the inside of the building was pristine and well-preserved, but it also said that Mr. Webb found that rental unit inspections were not warranted at this time. I'm curious as to why, in your opinion, on your knowledge, that was the case, and what would trigger this inspection?
What would trigger the rental unit inspection?
Correct. It's my understanding that there was no record of previous rental unit inspections in any of these dwellings.
I believe that's true, and I don't want to expound too much on rental unit inspections, whereas they don't fall into my purview. But I can speak to my department and Chris Webb's department. When he does a rental unit inspection, and we do a different type of inspection that we call certificates of inspection. A lot of those things overlap each other. So oftentimes, if we go into a building and we report back that the building is in really great shape, Chris, because he obviously has a massive number of buildings to inspect, will say, okay, well, we'll give them a dispensation for a certain amount of time. So I think if our report came back that the building on the inside was a disaster, he probably would have changed his mind and then performed that inspection. Our inspection report coming back and saying the inside of the building is in great shape makes him feel comfortable that he doesn't have to perform that.
Thank you.
Okay, is that it? Michelle?
Just going to add, it's my understanding that the rental unit inspection is triggered when a tenant changes. So for new tenants, they're supposed to be doing the rental unit inspection. So when the unit turns over, I think there are some larger buildings in the city that are exempt. They made amendments to the laws a couple of years back. The larger units, like the multi-building, multi-family, but that's my understanding, that's when it's triggered, prior to renting to a new tenant.
If I could expand on that, that's absolutely true. They are required every time an apartment turns over, and the larger buildings in the city do receive, if they receive a certain number of favorable inspections from the health department, they do get a certain amount of time where they're relieved of that. It's basically a reward for good behavior.
Okay. Again, my point was that it's pretty apparent that none of these inspections have been performed for some time, and it seemed like a pristine opportunity to have done such. Thank you.
Very good. Does anyone else have any other questions for Michelle or the building commissioner or? No? Okay, very good. Well, at this point, we'll take testimony from anyone that would like to speak in favor of the petition. Anyone speaking in favor?
Good evening, members of the Planning Board. My name is Ryan O'Malley, Ward 4 City Councilor. I hesitate to come up in favor, to be honest with you. It's going to be more of a conversation because as I indicated last time, I feel like we're stuck between a rock and a hard place with this one. It's kind of unusual. The city planner and I have been communicating back and forth about how to kind of go forward with this, as well as the building commissioner. As I stated last time, I think one of my the top priority is really to make sure this building is safe. It's not quite clear whether or not we can enforce updating the fire apparatus to a sprinkler system and bringing it up to code generally unless a special permit is granted. We are also, so that's priority number one, make the building safe. One of the tools to do that would be granting a special permit. I also am aware that we don't necessarily want to award bad behavior or for the fact that it was operating as an illegal 7 and sometimes 8 unit building for the last 30 years. But we are stuck between a rock and a hard place also because 7 of the units are occupied, and if it goes down to 5, 2 of those units are going to have to be, I'm assuming, evicted. They probably won't leave willingly right before the winter. They're my residents, they're our neighbors. It puts us between in a really weird place. So one, if a special permit would be granted, I would love all of the conditions that the building commissioner and the fire commissioner or the fire chief put in there as conditions. And I'm trying to think how we can also make this, right, considering the fact that it hasn't been right for so long. The petitioner, Mr. Snow, said one of the reasons why he thinks this petition should go forward is because his units have been maintained at a, or on the market at a lower market rate than normal. He's called them affordable. I haven't been able to verify the prices of the units. I can only take him on his word. So I'm thinking that if there's a way we can get this building safer, but also make up for the fact that it has been operating illegally for so long, one of the ways that we could do that is by adding an additional condition that says a certain amount of the units should be permanently deed restricted as affordable units. This is a priority of the city. I'm sure you've heard the mayor and the city council have kind of moved forward with starting the process for inclusionary zoning, various other programs that the mayor's office and the MRA have kind of come up with. I have shared this with the city planner. I'm not sure if you have copies for the committee, but we do have a chart that shows what affordable rents are in Malden, and this is information from 2019, 2009, and 1999. It shows based on the number of family, or the number of persons in a family. It shows it at 50% of the MFI, which is the median family income, and it shows it at 80%. It will show you the total income level that would be at, and it also shows you what the affordable rents would be at that level. And my understanding is that would be about 30% of someone's income is what's considered affordable, or anything more than that would be considered rent burdened. So there's that resource here, which you do have a copy of. In addition, there was some question about whether or not putting a condition of affordability and a permanent deed restriction would be challenged in court. Anything can be challenged in court, but the research that I have been provided, which you also have, shows that it is accepted under state law that a condition of a special permit can be affordability. On page 6 of the paper that you have, which is called the Local Action Units Guidelines.
Just to clarify, I didn't get this till like 5:30. I didn't make copies because I didn't know if it was even going to be part of it, so I presumed you would present the info that you wanted. I do have one copy if anybody wants to see it, but I didn't make copies for everybody.
Just for the, I just meant you have the copy.
Right,
like
I have a copy
body.
in the record if anybody wants to see what he's referring to.
I can make copies also if anyone's interested. But just as a brief introduction, local action units are affordable units created as a result of intentional action by a community without a comprehensive permit, and which meet the requirements for inclusion in the subsidized housing inventory. The subsidized housing inventory is that number that we try to get to, that 10% that they talk about. We have gone through the partial housing needs analysis, which was recommended by this body. And we also did the general land use analysis, which showed that we were beyond the 1 point something percent. That's defined by state law, and state law can be changed. So while we are currently over the 10%, in 2020, we may go below the 10%. And if that law is changed in the future, the 1.5 harborage that we've gotten to is not guaranteed. So I do think why I say that is it is important for us to continue to try to get a certain amount of affordable units in our community. And I think this is a unique opportunity to do that, especially considering the fact that the petitioner has said that one of the reasons why he has been a good neighbor is that he's kept his rents affordable. Now, he also said that his intention is to sell this property. So the next owner of this property has no requirement to keep them affordable. The next owner could jack the rents up. And as we've seen in some other locations, for instance on Park Street, 33 Park Street, United Properties, which is owned by Andreas Citos, he bought that property and jacked the rents up by 50%. The vast majority of the tenants in that location have been displaced. And he has just bought another property on Park Street. And if past behavior is any indication of future action, you're going to see the same thing happening there. So I believe that regardless of what happens, this man will sell this property, whether it's 5 or 7, there's a good chance that the people who live there now are going to be displaced. If a special permit is not granted, there's a chance that 2 of the families that live there or the individuals that live there will be displaced immediately. It happens to be right before the winter. I don't think that's ideal. But if we were to put in this, that a certain percentage of it, maybe it's just the 2 additional units or 1 additional unit, or it's all the units, there's ways that this body can do that and take action now. On page 10, if you are interested, there are tips for drafting local improvement documents. And basically it says that in drafting a special permit that includes a condition to require 1 or more affordable units, it is advisable to be as clear as possible about the terms of affordability, referencing existing laws and regulations to the fullest extent possible. Any special permit condition or memorandum of agreement requiring the provision of affordable units should include the following: the number of affordable units, a description of affordable unit mix, that would be 20%, 80%, or something like that. A clear statement of the term of the affordability, 30 years versus in perpetuity. My recommendation would be have it in perpetuity. A clear reference to a plan showing the location of the affordable units. I believe that we do have plans from this petitioner. And a clear reference to local action taken that resulted in the creation of the affordable unit. So the local action that would have been taken would be that we have a property that is currently operating a illegal building with 7 units de facto when it only has 5 de jure. It's literally operating outside of the law. By granting them a special permit, which would potentially legalize 1 or 2 of those additional units, you're taking that action. Not only are you taking that action by legalizing those 2 units, you're also granting them some relief of their dimensional control violations. And then number 6, most importantly, the document should include a clear directive that the unit should meet all requirements to be approved as a local action unit by DHCD and be eligible for the inclusion on the subsidized housing inventory. This just protects us to make sure that what we're doing here isn't twisted by some lawyer down the road so that they're not actually going to be affordable units. And lastly, it needs to be, I believe, filed at the Registry of Deeds, which we learned is a pretty important step that hasn't been taken in this property. And I'll finally end on the fact that it is currently operating as a 7-unit building, and it has so for the last 30 years. It did get a variance in the 80s by the Board of Appeal. It did not, the prior property owner did not register that with the Registry of Deeds. That was a fatal flaw. It doesn't excuse the actions of this property owner by not bringing this to our attention sooner. It doesn't excuse this property owner for not taking care of the property in terms of what my expectation would be. But I do think we owe the residents that are living there some type of opportunity to stay in their home and make it safer. Thank you.
Councilor, you referred to some pending legislation that's going to change the 10% rule. Could you expand on that?
I didn't say pending.
Well, you said that it might, the state it may overturn that. Is that just speculation, or was that something you know is in process?
Well, so the law that governs this is Massachusetts General Law, Chapter 40B. That's what dictates these local action units. That's also the state law that dictates the Chapter 40B threshold. Like any law, the legislature can change the law. I don't know how many communities other than Malden who have gotten, no one's gotten pre-approved for the general land use analysis that we did. We might be the first to prove that we are above that 1%. All I'm saying is, if the legislature sees that more communities are doing that, there's nothing to change them from changing that percentage.
So you don't know of something, you're just preparing for the future?
Laws can be changed.
Okay. With regard to this, 2 units, is that what you're recommending?
That would be my bare minimum.
Is it premature in light of the pending action you mentioned that was coming down for inclusionary housing?
I do not believe so. I believe this is the perfect opportunity to actually take action, to put our money where our mouth is.
Why is that?
This is before us.
Okay.
And the petitioner has said that one of the main reasons why he is a good neighbor is because he's made his building affordable. The next owner might not do that.
So 2 units and an updated fire system.
I would think that would be ideal.
With that, as opposed to 30-plus years of noncompliance.
And not putting 2 families or more families on the street.
Well, we don't, no one said they were going to be out tomorrow, right?
33 Park Street, it literally occurred.
Well, this isn't Park Street, this is Linden Avenue, And as I recall from the last meeting, the petitioner had said that he wouldn't throw anyone out, that if they did have to do it, they would give time to transition.
I think that is, I mean, that's the question for this body as well as the building commissioner. I mean, how long do we allow a building that is operating outside the law to continue to do so?
It seemed almost 40 years.
Yeah, I mean, I think that the question is, you know, I think it puts the residents in a very precarious position.
Yeah, certainly no one wants to see anyone thrown out in the street with the advent of winter coming.
Exactly, especially in November, October.
Okay, Eric, did you have a question for the counselor?
Yes, I did. Thank you, Chair. The counselor offered to give us copies of his literature. I would take it.
Absolutely. I would just have to go and make those photocopies.
I'm just kidding.
I can.
But on a more serious note, Counselor, I was curious as to the data that the affordable housing data that you referenced. What is the source of that data?
The source of the data. The source of this data is, it says MHP. I got this from the MRA, Evan Spatrini, he's their planner.
Massachusetts Housing Partnership. And I'm sorry, like I said, I didn't make copies for everybody because I didn't think you were going to read a 20-page handbook here. I certainly will provide it to the board. I have one copy that I can share if people want with that section highlighted. I also have this copy of the rents. And I do have, if the board is inclined to go in that direction, I would certainly make a recommendation as to what the condition should state. I did have a chance to quickly review that before the meeting, but again, I didn't, whereas that really hadn't been part of the petition, even though, as the council said, we exchanged a couple emails, and I knew this was going to get brought up. I wasn't really sure to the extent, and had already, finalized the recommendation and report before receiving this information.
Yes, if you could definitely do that, because
Yeah, I
what
will
the council
definitely
said,
give it-
coming down the pike is.
Yes, no, and it's something
Gonna be
important for
germane.
us to know, because I was not aware that was, I thought the petitioner needed to agree to it to make it really withstand challenge. That was always my understanding in general for conditions, that if the petitioner agrees to it, it's, it's got an appearance that it's going to be considered reasonable. If a petitioner objects to it, there's a greater likelihood that it wouldn't be. But, I appreciate the council bringing this to my attention, and I will definitely make copies. I can even email it to the board.
Eric, did you have something else?
Yes, I did, actually. Thank you, Mr. Chair. I was curious about the source of the data because I do remember seeing some similar numbers, but not in the detail of going back these numbers a year, so I would like to see that. With regard to you mentioning us entertaining the possibility of deed restriction, has the council itself or any committees of the council been broaching this matter currently?
Deed restriction, yes, the ordinance committee has been talking about inclusionary zoning. In the inclusionary zoning ordinance, when it has to do with the sale of condos, for instance, that would require a deed restriction for the affordable units. It's still in the infancy on their part. They're doing. I'm not on ordinance this year, so I don't know the particulars, but I do know that's something that they're discussing.
And that, to your understanding, that pertains solely to condos, but not in instances of this matter.
No, it would also So it would also have to do with rentals. Deed restriction, regardless of whether it's rentals for ownership, condos for ownership or rentals for renting, a deed restriction would be required in order to keep it affordable in perpetuity or for any portion of years. If you look at some of the other buildings around here, what ends up happening is the negotiation they did was like for 30 years. And then once that 30 years is up, you have to pay them to keep it affordable going forward. My proposal here would be let's make some portion of these units affordable in perpetuity so that we don't have to continue to do this. And we know that will also always count towards our local action units.
And you feel confident that taking such actions is in the purview of this body?
Absolutely.
Thank you.
Thank you. Counselor, anything else you'd like to share?
No, I do want to share one other thing, just for an example. Creating local action units as a condition of a special permit. Communities can, in certain instances, negotiate with a developer on a case-by-case basis to create local action units as a condition of a special permit. The Massachusetts Zoning Act, Massachusetts General Law, Chapters 40A, Section 9, provides for the use of special permits to grant incentives for the creation of housing for persons of low or moderate income. In these cases, the local action is found in the one-time decision of a local board to issue a special permit, subject to a specific condition requiring that they create one or more affordable units. The planning staff in Salem reported in 2018 that while they do not have an inclusionary zoning bylaw, the city's planning board has, in response to a surge in mixed-use and multifamily developments in Salem's historic downtown, had successfully negotiated a 10% affordability requirement for new residential projects. If this body would like to grant a special permit for anything, when it has to do with residential, and you think that it is in the best interest of the community that a certain percentage of those units be affordable, you have the power and the ability to do that, even without an inclusionary zoning policy. I did not know that until today. It sounds like it was new for many people, but I think that this is a great opportunity to make right a really difficult situation, and also, I guess, maybe set a new course going forward. Thank you.
Michelle
Yeah, I
has
just
two
had a couple
for you,
questions.
Counselor.
What would you recommended the 2 units, or two of the 7. What would you recommend? You said that this description of affordable unit mix, that means whether it's low or moderate income. What would you recommend the percentage of that's where you choose the percentage
On this table?
number? So,
I had the same internal dialogue with myself.
well, I'm asking just before you get to that, what would you recommend? And I guess my other question that's kind of connected, so you can, answer it all together, is this would be if we're creating new units. The units already exist and people are renting them for a certain rent that we don't even know what the rent is. So let's suppose, for argument's sake, we say it's going to be 80%. And the people, the rent, even though he did say it was well below market, I think that was the term, maybe they're actually not at the affordable rate. So if if the board decides, okay, 2 of the units are going to be at this level of rent, affordability, I should say, what if 2 of the units that are there are not at that level? So that means those 2 units, the people would be allowed to stay for the lesser rent, or how do you think that would work? Because we're not actually creating new units. The units are already there and we know that they're occupied. So if you can just give us more info or ideas, because I hear what you're saying and I read it and it sounds sort of like you could do it, but then it also sounds very complicated because of this particular situation.
This situation is very complicated.
Thank you.
I do agree with you. And I've also tried to figure out how this would go in our heads. And I think that the same way, because we just found out about this today. If I had found out about this before today, we would have had this conversation. We probably would have flushed this out. I think we need information. We need to know, and I think we have some of this information, maybe. I don't have it in front of me, but you might. The floor plans of the units, the number of bedrooms per unit. My understanding is they're pretty much all, single bedroom.
They're all 1 bedroom or studio.
So we know that. And then I would say that, so I believe on this chart, efficiency is going to be a studio, and a 1 bedroom would be a 1 bedroom. So I think that we're going to be dealing in those areas there. And then from there, you need to decide, or we can decide as a community, whether or not we just want 2 of the units, or do we want to do this to all of the units? I don't know if that would be a reasonable condition. I'm not recommending that, but I think that this is kind of a new thing for us. I would say that we request what the rents are for all of the units, and then maybe whichever are the lowest ones or most in line with these rates here, those are the ones that we deem to be the affordable units going forward.
But doesn't it really depend on who's in the unit and what their particular financial circumstances are?
How you qualify someone for that unit is different than having an affordable unit. So the existence of it, the unit is different than the person. For public housing, yes, of course, the person's personal income information has to do with whether or not they're going to qualify for a public housing, subsidized housing unit. In the private market, as long as the unit is affordable, that counts towards our subsidized housing inventory. So
I just wouldn't want to see someone be forced to have to leave before Christmas or before Thanksgiving because they don't qualify for what we arbitrarily decided was.
I don't think that is what this is saying at all. I think you're misinterpreting it.
Okay.
This is talking about the affordability of the unit, not the income of the person.
Right, but once we deem it affordable, and there's a person in there who exceeds the limit.
No, the person doesn't exceed the limit. It's the unit. 2 different nouns, unit and person. The unit is affordable. That's what they can charge for that unit. The person is the person and what they can afford. Right, what this is showing here is that this is showing what you can charge for the unit per month.
Okay, well, I mean, that's it. I don't
Not
know
what
how
the
you
person makes.
I don't know how you get around what the person who's occupying that unit makes in determining whether they meet or do not meet the affordable housing requirements.
That is not what we're discussing here. What we're discussing here is keeping the unit affordable.
Okay, no, and I get that. And I understand that you want to make X number of the units. Well, but I also thought I heard you say you didn't want people thrown out into the street or having to move or having to do anything. And I'm just saying that there could be a possibility, and I don't know the people living there or what they're charging or what their personal financial circumstances are, but there could be a situation where no one in there qualifies for affordable housing.
There's no qualification.
And there are 2 units that need to be filled by affordable housing.
I don't think you're understanding what we're talking about.
That could be true.
We're not talking about the people, and we're talking about the units. And about keeping.
No, I get that. I'm just taking.
We are talking about the
step.
people, and that we don't want them to be evicted because we're saying 2 of the units are no longer or are continuing to be illegal. What I'm saying is we can add units to our subsidized housing inventory, the units. Mm-hmm. How they qualify, how the property owner qualifies, who lives in that unit, that is not what we're discussing. That would require, I think, a more in-depth conversation, likely the full inclusionary zoning ordinance. What I'm saying now is, if you're not prepared to act on something like this, I think that there's more information that's needed. One, what are the rents currently in each of the units? What kind of leases do they have in each of the units? Because that will help us understand, do they have long-term leases? Are they month to month? I think this helps us understand the impact of the decision this body is going to make. So to get back to Michelle's question, what would I be recommending? I would be recommending that we go with the 2, on this first page, maybe it's not the first page, fiscal year 19 affordable rents. You see households at 50% of the family median income. That shows a 1-bedroom as being at the 50% mark. The monthly rent would be $1,038. That would be the max they'd be able to charge for those one bedrooms.
Okay, hold on. Can I just interrupt you for 1 second? Because not everybody has that paper. And again, I'm sorry that you don't. But I think what the chairman's saying is what my question was. And this is from the Housing Needs Assessment. The deed-restricted units have income limitations that households must meet in order to be eligible for occupancy. Income limits are based on HUD MFI calculations. So that's what I was asking you. Are you looking at the 50 to 80? 50 to 80, which is the low income? You would have to decide, when you say these are affordable, are they affordable 30 to 50% MFI, low income affordable 50 to 80%, moderate income 80 to 100%? So I don't know if we can just say that they're affordable and then it could be any of those. I think we'd want to decide which of those categories are affordability. I think that's what it means when it says description of affordable unit mix, which I know is what the council's working on. What's the right percentage? Not just the 10% or 15%, but what's the right affordability percentage? Is it low income? Is it moderate income? Or is it very low income? And that number you just read, you read from the low income. You read up to 50%, right?
Yeah, and then I was going to say that, I was just going to give you guys the information,
Right.
that the 80% MFI is $1,561.
And that's moderate income
And that would be
according to
moderate.
the standards. So I think you would you would have to decide which of those categories. Because if you don't meet that, you can't, and if we deed restrict the unit, it is scrutinized who can live there. They look at your income. Do you qualify or do you not qualify? So I think that's what you was trying to say, Chairman.
And
There
that's
could be
fine. That's a
people
level of complexity
that live
that
there
we
that
may be
don't.
ahead of
Right.
ourselves.
Maybe we do need more time to get more information.
I
Yeah.
would be honest with you, I think this is a very complicated petition. And I am still learning about this, as I feel like we all are. I hate to see this drag on and on and on. But I think it's an opportunity here to kind of get this right and kind of flesh out those ideas. I just think it'd be a missed opportunity to get this building up to code, safe with new fire systems, and potentially some affordable units, which would help us towards our subsidized housing inventory.
Okay, thank you very much. Does anyone have any questions for, oh, well, actually, I got to go. Anyone else who would like to speak in favor?
Mr. Chairman, may I be heard briefly on this issue where?
Afterwards. You know, I just want to go through the rest of the thing. Thank you. Anyone else that would like to speak in favor? Michelle, do you have anything to read in favor?
I do have one letter.
Thank you.
I apparently do have these, too. This is dated October 9, 2019. It reads, "Dear distinguished planning board members, this letter pertains to discussion on 84 Linden Avenue, special permit, section 700.1.3.1. It is my belief that this building has always been a 5-unit dwelling. Presently, it is being used as a 7-unit with the basement apartment totaling 8 units. Many of the units are being offered as, quote, affordable. With that being said, I would support this request, but with caveat that a deed restriction be added saying these must remain within the affordable guidelines, 2 units. I would also request that on an annual basis audits are performed. Further, I would support any and all building commissioner and fire commissioner recommendations with regard to making sure this is up to all codes. I thank you for this opportunity and trust the Honorable Planning Board will make the right decision." Signed, Debbie DiMaria, Counselor at Large, 144 Maple Street, Malden.
Thank you.
That's everything.
Very good, and no one else would like to speak in favor? If no one's here to speak in favor, I will declare that part of the hearing closed. Anyone who'd like to speak in opposition to this petition? If you want to, yeah, it's fine, it doesn't matter. Is there
Did
anyone
find a
else that
couple
would
more
like,
of these.
anyone would like to
apparently.
speak in opposition? Michelle, anything to read in opposition?
No.
If I don't see anyone else looking to speak in opposition, declare that part of the hearing closed. Councilor McDonald, you wanted something? You wanted to
Thank you.
provide some information?
Well, just if I might comment on this issue that was brought up by Ward Councilor O'Malley. With all due respect to the Ward Councilor, and certainly not with the intent to minimize or marginalize the issue, it's a worthy discussion, to be sure. And I don't necessarily dispute the fact or the possibility of being able to impose conditions regarding affordable housing as being within the purview of this board. But I would suggest, and based on what I heard from the councilor, that this issue has not yet been decided by the municipality in general. Whether or not the city wants to make changes to or additions to or affect in any way current affordable housing, the current affordable housing status within the city, I would suggest is more properly decided by the legislative body for the city, that being the city council. We know it's being discussed, but we're not aware of any action that's been taken at this point in time. And we don't know if there's going to be any action taken with respect to this issue by the council. It is a matter that is being considered and discussed, but for which no formal action has been taken and for which no formal action may ever be taken. It also sounds, respectfully again, that at this point it is a solution in search of a problem. By the councilor's own admission, Malden is not deficient in terms of available affordable housing. And while it is certainly true that things can change and that laws can be changed, that's speculation at best. Right now, Malden meets its affordable housing requirements. And as a consequence, I don't believe that this particular property or this particular instance is an appropriate time for this body to wade into what is admittedly an extraordinarily complex issue. I think that's clear from the lack of information, and that's not a criticism of anybody, it's just an observation. There's not a lot of information available right now for this board. And you don't know the sense of the city yet, so to speak. You certainly know the sense of Councilor O'Malley, but he is one legislator on a multi-member city council. And there may be other city councilors in the city who feel otherwise, and the result of that might be that there are no changes of any kind made to this city's position regarding affordable housing. And again, I don't dispute that this board may...
Okay, if you could. I didn't ask you up to debate Councilor O'Malley's points point by point. You've basically you've expressed your opinion and what your concerns are. If you could wrap it up, that would be great.
That will be sufficient. Thank you, Mr. Chairman.
Thank you. Eric McCush. Can you hold on one second, Eric? Did you have anything to read in general, Michelle? In favor or opposed, or in general?
No, I did not.
Okay, thank you.
I mean, I read the letter from the building commissioner and fire chief and his email.
Right, okay, I just want to make sure there wasn't anything else. Eric McCush.
Thank you, Mr. Chairman. I have two questions. One for Councilor McDonald. Just in terms of bringing the building up to code, are you aware whether or not the building has a D-lead certificate?
That I don't know. De-leading certificates? I'm sorry, we're not certain, Mr. McCush, of whether there's been de-leading done in the apartments.
Okay, thank you very much. And my second question is, I thought this came up before, but outside of Chapter 40B, forcing buildings to have a certain percentage of affordable housing units wouldn't hold up in court. Didn't that come up a couple years ago?
What came up is a general requirement if it's not in our ordinance. We don't have it written into the ordinance. What was brought to my attention today is apparently you can put it in as a condition of a special permit. Again, I always thought, and I didn't do a lot of research, I always understood any condition, whether you restrict it, condo form of ownership, you can put it in if they agree to it, or it will be considered reasonable if they agree to it. The law doesn't require it, state law doesn't require it, and our city law doesn't require it. So I'm not saying that you can't do it. I did read documentation from this Mass Housing Partnership Group that definitely suggests that you can do it. And that was presented, as the council said, from the redevelopment authority employee that really kind of specializes in this stuff. So I think it is, at least this research is showing that you can put that in as a condition. I think there's a lot of questions. I have some suggestions as to what the condition should say based on my reading of that guideline, but I think you definitely would need to be very specific about what the condition said. And decide, what percent of family income, number of units, et cetera. And I'm not sure which of the 7 it says you're supposed to show which units. I don't know which of the 7 you would pick. I don't know which, we do have the floor plans, but I'm not sure which of the 7. And I don't know if that was kind of what your question about de-letting was, but yeah, so I don't know. What I saw today definitely indicates you can put it in as a condition.
Okay.
But
Thank you.
that's as much as I know.
Anyone else have any questions for Michelle? And Michelle's already taken us through the supplement.
I took you through the supplement, and I think we went through the original recommendation last time, but maybe we didn't.
No, we did.
We did? Okay.
We did.
Okay.
Unless anyone has any questions for Michelle on the original report? No?
And I did not, I maintained the same recommendation. I did not change the recommendation. So the same recommendation.
And that was?
To deny the special permit because it's an overuse of the property. It grossly exacerbates existing violations of density and creates new violations of open space. That being said, if the board is inclined to move forward, I would, before you take a vote would recommend certain conditions if you are going to move forward to grant a special permit.
Okay, does anyone have any comments? Patrick Fitzgerald.
Thank you, Mr. Chairman. Based on the new information that was provided to us for the purposes of tonight's hearing, my position essentially has not really changed. What I look at here is, yes, this property has been in violation of the law since 1981, which is the date I believe the petitioner stated that he purchased the property because the change was not perfected. However, what I look at here is the property owner's intent for the past 38 years, and I have not received any evidence to suggest that he had reason to believe that he was in violation of the law. The documents that I credit are the Board of Appeal decision in 1980 that approved this property as a 7-unit building, and the petitioner's testimony, which I credit, he made a number of statements against his interest that affects his credibility favorably, in my opinion, that he believed that when he purchased the property that it was a 7-unit property. And while he did admit to at least one, if not 2, instances where he had an 8th unit occupied, he explained the circumstances of one. He did state that when he became aware that this was only a 5-unit property, he had to evict someone else, suggesting there may have been a second time. But when you look at what the required finding that this board has to make in granting a special permit, the fact that this has been essentially operated openly as a 7-unit property with some issues with regards to snow removal that was brought to our attention that can be remedied or could have been remedied by other measures throughout the city, that it does not, and again, it's not that this proposal would make it less detrimental to the neighborhood. The standard is not more detrimental. And what I see the request here being is that essentially the petitioner is asking himself to be put in the position that he had a good faith basis to believe he was in when he purchased the property in 1981. So I would be in favor, and I guess a question for Michelle is, the petitioner, I don't know if he orally or otherwise amended the petition to only request a 7-unit as opposed to an 8. I don't know how that affects how we approach. It's,
I mean, you would grant a special permit to allow what you wanted to allow. You wouldn't necessarily grant the petition because the petition was for 8.
okay.
So I would say you would grant a special permit to allow use of the property if it's 7. And then, again, I have several conditions I would recommend, one being that the basement apartment be removed immediately.
Yeah, I mean.
You know,
Yeah, I mean, like I
so-
said, I think this is an opportunity to make it right and to require certain improvements that are recommended by the building commissioner. I take from the information that was provided to us tonight that, again, there aren't any major deficiencies in the condition of the property or the building itself. It's pristine and well-preserved with otherwise necessary maintenance that would be expected of a house of this age. I'm hearing that means of egress from the 3rd floor unit is not even required. So I think that the actions that are requested from the fire department and the building commissioner are reasonable to include a special permit for 7 units. So those are my thoughts.
Thank you. Ken Antonucci.
I agree with Patrick's assessment, and Michelle would like to know from you, what additional conditions other than the 4?
Can we hear from other people, Ken, before we go back to conditions?
Yeah, sure.
In case someone has a different view. Eric Henry.
Thank you, Chair. I don't think my view is different in whole with Patrick's and possibly what Ken was saying as well. But I do want to point a clarification is that the balcony area on the 3rd floor that had been had the ability to be used as an escape route. Was there steps leading to the ground? Could they potentially use that to exit the building? Yes. So I would like to see that it continue to be able to be used as an egress.
You may want to check the pictures in the package, Eric. There's a several foot drop from the bottom of the ladder to the ground.
And the building commissioner stated that it's not safe and it's not required, so I don't know that we want to require, he's stating that you don't need that second means of egress.
Relay that. Thank you.
Okay. Anyone else have any other comments? The comment I'd like to make is I think that 40 years in violation is egregious and should not be rewarded with adding extra units. Ken, if there's no other, does anyone else have any other comments or thoughts? No, Ken. Now, if you want to ask about what conditions Michelle has worked up.
What conditions beyond the 4 that Chief Finn and Commissioner Miller propose are you entertaining?
So those 4 conditions, I think the first condition should be all development shall be as per plans except as modified by these conditions. Then the next 4 would be what was recommended by the building commissioner and fire chief. So 1, the basement unit shall be removed, or 2, this would be condition 2, the basement unit shall be removed in its entirety. Common laundry may remain for use by the tenants. The entire building shall be protected by an automatic sprinkler system installed in compliance with 780 CMR, Massachusetts State Building Code, and NFPA 13. 3, the entire building shall be protected by a fire alarm system installed in compliance with 780 CMR, the Massachusetts State Building Code, and NFPA 13. And 4, condition 5, this would be the egress stairs and ladder access from the 3rd floor unit to be removed in their entirety. That balcony outside the 3rd floor unit is to be evaluated for structural stability and repaired or removed accordingly. Also, the water supply service must conform to all applicable codes.
And by that, what do you mean, Michelle? Fire codes for fire suppression in the event of a?
I think it's
or-
fire
Or within
suppression.
the building itself?
I think it's fire suppression and within the building, because I believe that there was record, if you just give me a minute, in the old file pursuant to the 1980 variance, there had been a statement by the city engineer at the time, which I believe I brought to your attention last time, that the existing domestic water service was not adequate for a multifamily dwelling. That was a memo from John T. Kelly, the city engineer, dated March 25th, 1980. So the domestic water supply was an issue back then. I think that's why the condition was in the variance about the water supply. I don't know if that would automatically be taken care of with the sprinkler. I think the sprinkler is the fire suppression water supply part. I think the domestic water supply part is maybe another issue. I don't know if that's one and the same, so that's why I had thought that was important. Water supply service must conform to all applicable codes. I don't know if anybody has any expertise on that, if that's the same thing, or.
Can I speak to that?
Yes.
All right, or at least ask a follow-up question to it. I believe that, in order to have a sprinkler system designed that meets all the fire codes and the sprinkler codes, it would require that designer to verify the flow into the building. Now, I don't know if I could ask Commissioner Miller, because I don't recall, is the domestic water supply and the sprinkler water supply two separate
They're saying
supplies,
yes.
or does it come off
Yeah.
the same water supply?
I'm sorry, Commissioner? There you go.
Because of the size of this building, it would be two separate water supplies.
Okay.
So they would most likely both get addressed.
Okay, so with the new supply for the sprinkler or the fire suppression system, they'd have to verify that. So we should also verify that the domestic water supply is also adequate separately, because there would be two separate feeds into the building.
Yeah, the flows get provided to us when the sprinkler design is submitted for a permit, and then they're reviewed by us and the fire department jointly.
That's just for the sprinkler system, though, not for the
Right.
domestic water.
Right.
So maybe the condition should read, domestic water supply service shall be adequate, subject to, city engineer.
City engineer,
City
yes.
engineer, approval of the city engineer.
Yep.
Or as determined by the city engineer. The city engineer, again, at the time, in 1980, didn't think it was adequate. So I'm
Yeah,
not
so
sure
if
if
we
that's
add-
changed,
Yeah, so
or it
if we add-
hasn't, and we weren't able to verify that condition.
So if we add that as a condition,
So,
separate from the fire suppression system.
yeah, I didn't even mention that, a separate, I thought it was a separate thing, but in your, couple of the board members are agreeing. So I guess the condition would be domestic water supply service shall be adequate or must be adequate, subject to approval of city engineer.
Yes, and then if that would be your sixth condition then?
Yes.
And then if you could add as a seventh, the portion of the last sentence from the letter from Chief Finn and Commissioner Miller, that the owner must perform all this work with the benefit of permits after review by both departments. Or does that fall under one of the other, the first condition of per plans?
Yeah, I mean, I think they have to do this work with permits. I don't think you need to put that in as a condition. You can if you want to, but I think I don't think they can do this work without permits. Well, I guess they could do the work
Yeah.
without permits,
Yes,
but.
yes. So I'd include that as a seventh condition.
Okay, so all.
The permits after review by both departments.
All work must be permitted after review by building and fire department, something like
Yeah.
that. All work must have proper permits.
Okay.
I mean, that includes the review, so I don't think you have to review, must have proper permits.
You all set, Ken? There are other people
Yes.
that want to weigh
Yep.
in. Patrick Fitzgerald.
Thank you, Mr. Chairman. I apologize if this was addressed. I may have missed it. The condition number 4 that's in the September 24th letter addresses 2 issues, the stairs and ladder as well as the balcony. I would go so far as to recommend that there be a separate condition that the balcony shall not be used as a means of egress, requiring if they want to, they would have to come back before the board to amend the special permit, given that there's uncertainty about the structural stability of it. And procedurally, Michelle, again, this is a unique situation. Typically, the petitioners would need to show compliance with the terms of the special permit to obtain an occupancy permit. Where these units are already occupied, how does that work?
Yeah, I'm not sure. I'm not really sure about that. They don't have an occupancy permit for a 7, so it's, right now, they could obtain an occupancy permit for a 5. I don't know if they actually have one, or it's just been determined that that is a 5. I'm not really sure how that would work. I mean, maybe the building commissioner could address that.
I mean, could we add a condition that they obtain a certificate of occupancy for 7 units within a reasonable or definitive period of time decided by us?
If I could
Commissioner Miller?
weigh in on that. So if you decide to grant the special permit and declare it a 7-unit building, that is essentially no different than granting a special permit for constructing a building with the certain conditions which Michelle has just read off. So once those conditions of the special permit have been satisfied, I would then automatically issue them a certificate of occupancy as a 7-dwelling unit. So that would be part of the completion of the permitting process.
And they just remain in violation until that time.
Right, they'd be working their way out of violation towards an end of 7 units, right?
But I mean, I think you could put in a time frame. This, you could put in, I think you could put in a time frame.
I think
For the
we
work
should,
to be
where,
done.
again, until they get that 7-unit occupancy permit, they're in violation. So there needs to be swift action in order to comply. What would you think would be a reasonable amount of time for them to come in compliance with the terms?
The most difficult part's the sprinkler system, obviously. The rest of it's kind of easy. And that takes, obviously, a design and approval, possibly some recommendations from us, and then going out to bid. So 6 months?
Thank you.
You also have statutory requirements that the special permit's only good for so long. Your building permit's only good for so long, so it's not like this could drag on like it did in 1981.
Right. Thank you.
You all set, Patrick?
I am.
Ken Antonucci.
Yeah, plus, just to add on to what Commissioner Miller was saying, I mean, requiring a time frame at this point, heading into the winter, most likely going to have to do some utility work, digging. I mean, I would think at least 6 months if we were going to entertain any kind of time limit, just knowing we're going into the winter. And you're not allowed to work on water lines and things like that through the winter. So if
Very
anybody
good.
does want to entertain a time frame, I'd say it'd have to be at least a minimum of 6 months.
Thank you.
And could I just ask, well, I didn't understand the comment about the condition about removing the egress stairs and ladder. But then the second part is the balcony is to be evaluated and repaired or removed accordingly. Patrick was saying it may not be used as a second means of egress? Is that what you were saying, add?
Right. I think this is, the way it's written is a little bit vague in saying, go out and get evaluated. I think at this point in time, just say you cannot use it as a means of egress. And if they want to come back before this board to amend the special permit with a specific design, then we can entertain it at that point in time. But what I'm hearing from the building commissioner is that it doesn't appear, at least based on his opinion, to necessarily be safe, and that it requires at least some evaluation, repair, or removal completely.
Okay, so the part about the egress stairs and ladder being removed,
In
so
their
that's what
entirety.
connects you to the balcony. So then, but you're saying even with those things removed, you don't want someone to think they could use the balcony as a second means of egress?
Yes.
So were you thinking?
Because
keep
they
it-
would have to, if they wanted to build another staircase, they would have to come before us.
Oh, they would
correct,
have to, right. So just maybe add, the balcony may not be used as a second means of egress? Is that what you're saying?
Yes.
Okay. To the end of that sentence? I mean, I don't think it can be if they remove the stairs and
Right.
ladder, but we can, if that's what if people want to do, that's fine with me. The balcony may not be used as a second means of egress.
Okay, Patrick, were you all set?
Yes, thank you.
Does anyone else have any other comments? Does anyone want to entertain affordable housing units, reservation for it? Ken? No? Okay. Is there anyone? Eric Henry?
I just want to make a comment about it. I think it's something that's, we're definitely going to probably face in the future. We're woefully unprepared to do at this time, but we should become knowledgeable and prepared for future actions. Thank you.
And just to clarify, this isn't new. We've had this in the past where we've had affordable housing requirements as part of our zoning, so this isn't new at all.
On a 7-unit?
On any new building,
Any new building,
yeah.
and this is constituting a new building?
No, I'm just saying that it's not uncommon. We have had it in the past.
But not on existing structures?
Mostly, we saw it on renovating existing structures and new building.
Thank you.
So if you look at this and say we're going to renovate, 1/7, almost 20% of the building, I don't know if that would trigger it. I mean, it's a long time ago. I don't recall the specifics of the ordinance.
I can just, what's the threshold? 7 units a day, 20 units, 3 units? There's a lot that needs to be fleshed out, but it is definitely.
No, agreed.
need
I'm
for-
not disagreeing with you. I'm just, okay, Patrick Fitzgerald.
Thank you, Mr. Chairman. I think first and foremost, this is based on the facts and circumstances of this petition. It's not a candidate for even a discussion, but going forward, based on what the city planner had told us about an apparent authority for us to require certain deed restrictions, I would ask that we have some sort of opinion or advice from the city solicitor about what this board is able to do with such deed restrictions so that we can apply it consistently throughout the city and throughout any request that comes before us.
Okay, anyone have any other comments? Bless you. Anyone have any other comments? No? Okay, is there a motion? Ken Antonucci.
Mr. Chairman, I'd like to make a motion to approve the special permit with the 8 conditions that were read.
Very good. Ken's made a motion to approve the special permit with 8 conditions that Michelle went through earlier. And is there a second for Ken's motion?
Before you do that, so the special permit is for 8. So you're not, in the plans show 8, so you're not, it's all development as per plans except as modified by these conditions.
Right, and the condition includes, the first condition is to remove the basement apartment. So if you want to reiterate that it's the special permit for 7 units.
Yeah, I
I'll
think
modify
maybe
it to say
the
that.
property may only be used for 7 units.
Yes.
Okay. So
if the-
you're approving a special permit to allow use for 7
allow
units?
use for 7 units.
With the 8
With the 8 conditions, and if there's any confusion, the 8th condition was that obtaining the occupancy permit for the 7 units.
Yeah, I only had 7 conditions. What was the 8th?
Was obtaining the occupancy permit. In hearing from Commissioner Miller, it sounds like we don't have to put that in as a condition, but I don't think it can hurt to have it in there, because what if somebody forgets? Somebody forgot to record the deed at one point, right? So I don't think it can hurt to put it in there, even though it should automatically happen.
Okay, is that it, Ken?
Yes.
Patrick Fitzgerald.
Actually, can I get clarification of what the 8th condition is how it's gonna read?
I just wrote down obtain an occupancy permit for the 7 units.
Without a date?
Yeah, you putting a date in, or, this permit expires in 1 year from date of granting. But if they start working under it, they're exercising their rights, so that doesn't mean they have to finish within 1 year. It means they have to start within 1 year. So,
Is there a second? Are you all set, Patrick?
Yes.
Thank you. Is there a second? Ken Antonucci, you made the motion, you can't second it.
Yeah. You sure? No. No, I was going to say, because this seems to go back to Patrick's concern, to make sure this gets done in a timely manner. For that 8th condition, can we say obtain occupancy permit for 7 units as soon as practicable?
You either want to put a date or you don't want to put a date.
I don't want to put an exact date, but I think how would we make sure this work happens? I think that's the concern, is that this could just get dragged out, and even if they apply for the building permits and get the design, I mean, we want to get this cleaned up as soon as possible. But there are some, real constraints that they're going to have to face getting this work done.
Okay, thank you. You all set, Michelle?
I just have obtained occupancy permit for 7 units. I would recommend you put a date in there.
Okay.
Within 1 year from date of granting,
It's your motion, Ken.
Sure.
so that will be 1 year from today.
1 year from tonight.
Okay, is there a second for Ken's motion with eight conditions? Diane Chuha.
I second.
Diane Chuha seconds Ken's motion to approve 7 units and 8 conditions. Hold on a second, let me get rolling. 7 units, 8 conditions. Okay, let me try to get ahead of everyone. Okay, Michelle, you can start.
Ken Antonucci,
Yes.
Diane Chuha,
Yes.
Patrick Fitzgerald,
Yes.
Tawadej Gebrselassie,
Yes.
Patrick Hayes,
Yes.
Eric Henry,
Yes.
Eric McCush,
No.
Henry Susi,
Yes.
Chuck Iovan.
No.
So 7-2. The motion passed.
Very good. Okay, so the next hearing we're going to hear is 102 Main Street. Ken, if you could read the notice, appreciate that.
The Malden Planning Board will hold a public hearing in the auditorium on the first floor of the John and Christina Markey Malden Senior Community Center, 7 Washington Street, Malden, Mass., at 7 p.m. on Wednesday, October 9th, 2019, on the petition of Chun Sing Lee for a special permit under Section 300.3.4.25 of Chapter 12, Revised Ordinances of 1991 as amended of the City of Malden, seeking to allow licensed massage therapy salon use of property in the neighborhood business zoning district, namely to allow acupressure massage business at 102 Main Street, comprised of approximately 1,000 square feet, located on the first floor of the property known as and numbered 98 to 102 Main Street, Malden, Mass., also known by city assessors parcel ID number 065316621.
Very good, thank you. Ken, is the petitioner present? If you could come up and give your name and address for the record, please.
Hi, my name is Tong. I'm the interpreter and representative speaking on behalf of Mr. Lee when necessary. So Mr. Lee, what's your name and address? 你的姓名和地址是什么？
CHUNSHENGLI， 我的住址是18 Main Street, Malden.
So you live at 80 Main Street?
是80号。
对
80 Main Street.
80.
80.
Yeah. And if you could give your name and address too, sir?
Oh, yes. My name is Tong Liu. My first name is Tong, T-O-N-G, and my last name is Liu, L-I-U. I live at 36 Ripley Street in Malden.
Thank you. Now, if you could describe what the petition is and what you're looking to do at this location.
Okay. Mr. Lee is proposed to open an acupressure massage business at 102 Main Street. Acupressure is a form of alternative medicine which is based on the theory that life energy flows through certain routes on your body called meridians. And by applying physical pressure on certain meridians and acupoints on your body, it achieves certain health benefits. Unlike Western massage, which applies long flowing hand movements to the superficial muscle layer of stress relief and relaxation, acupressure applies systematic and sequential pressure to the acupoints in order to correct blockages or aberrations in the flow of life energy through the meridians and restore health. Acupressurists uniquely recognize that stimulating an acupoint on one part of the body can trigger a healing response in another part of the body, that each acupoint can benefit a variety of complaints and symptoms. If you may allow, I'll ask Mr. Lee to give you details.
Okay.
说吧。介绍你的店在哪里？你准备开始做什么？
我现在是店，新店，现在是102号Main Street, Malden.
My store will be at 102 Main Street in Malden. 要做是什么？
Acupressure 指压按摩，指压，穴位指压。
For acupressure business. 你具体在哪个
No,
部位
could you be more specific about
Yeah,
that?
yeah.
Could you ask him what, does he make a distinction between acupressure and massage?
他就是问你指压和一般的按摩有什么区别？
哦，指压可以减轻人的疲劳，减轻病痛，以及穴位的这个经络的疏通，对人体疾病有预防作用。
Yeah, it has certain health benefits. It's different from Western massage that it's based on the Chinese medical theory of meridians, which is like in your body you have certain acupoints where life energy flows through. So by applying pressure on those pressure points, you can have healthy effects on your entire body.
So he's saying that massage is different than acupressure, which
Yes.
is what he practices.
Yes.
Let me ask you a question. Does he need to be licensed with the state?
Okay. I'll speak on behalf of him because we just made phone calls to the state Department of Health, and it asked us to refer the business to Board of Cosmetology and Barbering. And Mr. Lee visited Board of Cosmetology and Barbering at 1000 Washington Street in Boston and was told that he does not need the license.
So for what he practices, acupressure,
Yes,
the state said he did not need a license.
yes.
If he were engaging in massage therapy, he would need a license. Is that accurate?
Let me 所以说，如果你是要做按摩的话，你是需要执照，对吧？但你说的不是按摩。
对，我是这个 acupressure，就是指压，指压是一种特殊的方式。它的特殊性是压住穴位和这个经络的疏通，对有疾病的人能够减轻痛苦，能够减轻病痛，能够放松身心。
Okay. Yes, yes. So, Mr. Lee said that it's different from a normal massage practice. It's a special form of acupressure, which he applies pressure on certain acupoints on your body to relieve you from certain diseases.
Okay. And Michelle, the reason why I'm asking this and being so detailed is there is a difference between the city's definition and the state's definition.
Yes.
And whether you need to be certified or not. And I just wanted to try to get in your own words what you believe it to be so that we can then proceed accordingly.
We do believe that it's different from massage.
Okay. Can you tell us a little bit about the space itself? How many people are going to be working there? How many beds? I think there were 4 massage couches and 3 tables that are cordoned off for privacy curtains. Could you describe that a little bit more?
你能不能描述一下你的这个店的空间的布局是怎么样的？还有你会雇佣多少个工作人员？
布局是进门的右手边是3个床位，是敞开式的，是开放式的。左手边是足疗，4个足疗沙发，就这些。
Okay. So when you enter the door, on your right-hand side there will be 3 beds. You can see them straight. And on the left-hand side there will be 4 sofas for foot acupressure. So 是在脚上，是脚上。
就是说，就是指压足部的穴位。
Yes, acupressure on the acupoints on the feet. 你准备雇佣多少个人
？4个人到5个人，4至5个。
4 to 5 people. 同时吗？就是在同一时刻有4到5个人吗？
没有，我现在正在招聘，我正在招聘工人。
He said, I'm currently recruiting massagists. 就他是说他同一个，你是说整天都是4、5个人同时在工作吗？还是他们有不同的分开的时间上班？
不是，都在同一个时间，有互相交接的，都有休息时， 每天都有休息时间，工作4个小时，休息1个小时。
Yes, at the same time, but they may take a rest during their work. For example, working 4 hours and taking 1 hour rest.
What are the hours of operation? How long are we open during the day, and how many days per week?
营业时间是什么样的？每天几点到几点？然后一周几天？
和这个四拐弯木一样，9点10点到9点，晨出南。
然后一周几天？
一周7天。
So the same as my store on Square One More, from 9 a.m. to from 10 a.m. to 9 p.m. Open 7 days a week.
Where does he expect 4 to 5 people to park for the 11 hours he's going to be open?
你怎么解决这4到5个人的停车的问题？
就我自己开车，他们不开车，就我接送，他们就走路就过来，走路就从80号到102号，走路就过来。
Only he drives. The rest of the workers will be walking to work.
Okay, but he's coming from 80 Main Street, so I imagine he can just walk to the couple floors down.
他说，如果你住在80号 Main Street 的话，你自己也可以走路过去，对吧？
我还得去4拐弯木。
He said, but he also needs to go to Square One More shop every. Yeah.
Okay, so he won't be necessarily there all day, each of the days for the whole time you're open.
所以你不会在摩顿这个地方一直全天在这个地方，你也需要去另外那个地方，对吗？
不会，我全天在这里，哪里我也不去。
No, I will stay at the Modern store every day.
How much trash does this use generate? Do you generate any trash of any sort or specific to this use, or is it?
你这个营业每天产生多少垃圾？
基本能产生，每天能产生很少，就是怎么讲呢？
几包吗？几袋？
能产生1磅到2磅，1至2磅，2磅2磅。
Very few, maybe 1 to 2 pound.
And then I imagine the bigger thing is the laundry, and it looks like you have laundry the plan like that.
还有洗衣服的问题怎么解决？你这里面有洗衣间的，对吗？
洗衣服的问题，我都在这个80号，在我那个公寓里边洗。80号公寓，我住在那里。
Okay. Laundry wouldn't be a problem. I can watch them at my 80 Main Street apartment.
Currently in this Square One location, how many customers does he see in an hour on average?
就是平均下来，在 Square One Mall 那个地方，你的店1个小时要接待多少客人？
很难讲，有时候多，有时候少。平均讲，每个小时一天能10个到15个左右吧，15个客人左右，每一天。
It's difficult to say. It varies a lot, but on average, for each hour, maybe 10 to 15 customers.
10 to 15 each hour for 11 hours, or is it?
是10到15个每小时吗？
不是，是一天。
Oh, sorry, per day, per day. Yeah. 他说，如果你每天接待10到15个人的话，你每个小时只有1、2个人，你为什么需要4到5个人呢？
至少5个人是在这个，不是安排在这个新有开的这个店，摩登这个一个。
他问的就是摩登这个店。
啊？
他问的就是摩登这个店，为什么需要这么多人？
摩登这个还没开业呢。
不是，他问你开业以后为什么需要这么多人？
因为我有很多客人都在，很多 customer 都是在这个摩登这住，都是摩登的，都在摩登住。
He said he already had so many customers in the modern area.
Thank you, Mr. Chairman.
Oh, sorry, Mr. Lee, just have one really important thing to ask. So in his plan, each worker has 1 day off in 1 week.
So that was part of my question. So you will have 4 to 5 individuals working 11 hours a day, 6 days a week?
他说：“那你想雇4到5个员工，每周6天，11个小时工作吗？”
No.
那是怎么样工作呢？
一天工作，每个人最多能工作4个小时到5个小时。
Okay, so each person works at 4 to 5 hours per day.
But you're open more than 5 hours a day.
但你每天工作是11个小时，那你怎么能够过来呢？
不会的，因为我跟家很近嘛，没有那么多的客人，这样没有客人他们就休息。
Okay, so because it's so close to his home, they can be very flexible. When there are no customers, more workers can take rest.
Okay. What, you said that you're in the process of recruiting employees?
你说你正在招聘工人，对吧？
Yeah.
So you don't know what mode of transportation they're going to use to come to work, correct?
那么你没法确定他们到底通过什么样的交通工具来上班，对吗？
这不用交通工具，我就在这路上都可以租房子，这路上就可以租，路上就出租房子。
He said he can provide housing and renting for them.
Where?
在哪里？
就在路上，在这个102号的路上，在3楼。
Right above on 102 Main Street, on the 3rd floor.
What's up there?
那楼上是什么？楼上是啥？
这出租那个住房的，就是这个房产公司的房子，他在路上出租。
The upper floors are also for renting.
Do you own or rent that unit?
你已经租了那个地方吗？
没有，我去问过了。
Not yet, but he had asked about it from the property manager.
What type of training and experience are you requiring of people who are going to be working here?
在那个地方工作的人需要什么样的资质和训练？
就是训练指压穴位一种按摩，指压穴位
需要什么证书吗？什么？
没有特殊训，就是指压按摩，指压穴位。
Just acupressure skills.
So is there any type of schooling or certification that these people need to have had to be able to perform this type of service?
他们需要任何的学校的训练或者是证书之类的东西吗？
他们不需要，有我在，他们不需要。指压按摩，这既没有危险，也这只是一种，我教给他们的是一种这个放松，肌肉放松和这个减轻这个压力，放松和那个缓解疲劳。
No, they don't. They just need to learn the acupressure skills to relieve people from their muscles pressure.
How are they going to learn it?
他们怎么学呢？
他们是通过我的那里，来之前我要教给他们。
Before they start to work, I'll teach them myself.
And what type of training and experience do you have in acupuncture?
那你有什么样的资质和资格呢？
我有这个按摩学校的证书。
I have a certificate from massage school.
But you say massage is different than acupuncture?
Excuse me, Patrick, he's saying acupressure, not acupuncture.
I'm sorry.
Because I think acupuncture.
Okay.
Yeah.
So is acupressure different than acupuncture?
Yeah.
Okay. So what type of training do you have in acupressure? I apologize.
你在指压方面有什么样的证书？
指压方面，我这里也有，都有。有这个按摩证书，有按摩指压证书。
I do have a massage/acupressure certificate.
What is massage/acupressure certification?
Acupressure 是一种特殊的指压方式，你翻译吧。
不是，你是什么样的证书？你证书到底是什么样的？
证书是按摩的，我是指压，是按摩，指压是按摩的一种特殊方式。你跟他说讲。
Because in that certificate, acupressure is considered a special form of massage.
And where did you receive the certification?
指压不需要证书。
不是你的那个证书是在哪拿的？
我的证书是在学校拿的，按摩学校拿的。
I got my certificate from a massage school.
Where?
在哪里？
在我这里带的。
不是你在哪里拿的证书
我在加州，California。
？In California.
When you contacted the Department of Public Health, did you explain to them that you were going to be performing acupressure?
他说，当你跟那个健康部打电话的时候，你是告诉了他们你是要做 acupressure 的，对吧？
对的。
Yes.
And it's your understanding that acupressure is a subset of massage therapy?
你认不认为 acupressure 是 massage 的一部分？
Acupressure 是的，是一种特殊的指压方式。是的，是一种特殊的指压方式。
Acupressure is a special form of massage. Let me explain this a little bit, because in Chinese, actually, it's not distinguished. We both use the term 按摩. So in the Chinese language, it's obviously a part. Acupressure and massage are not so distinguished. It only comes to a problem when it comes to the Western English terminology.
Right. What I'm trying to understand is why he wouldn't be required to get a license through the Department of Public Health for massage therapy if it's a specialty of that. That's what I'm confused about.
Okay. So we did call Department of Health today, and they said it's not, it does not go through them. It should go to the Board of Cosmetology and Barbering. That's the answer we get. And he went to Board of Cosmetology and Barbering, but they said it doesn't go to that category either.
Patrick, you may want to hold off. That's one of the things that I was hoping that Nelson could speak to a little bit. We can certainly circle back to it after if you're not satisfied.
Yeah, I'm just trying to
with
find
it.
out what this petitioner's understanding of that, as he's the one who's requesting this permit and operating this business. And I think I'm satisfied at this point. Thank you.
Thank you. Eric McCush.
Thank you, Mr. Chair. Some of my questions were actually asked by Patrick, but one last one. Will we be serving any beverages like coffee, water, tea?
你会提供任何的饮料吗？比如说酒啊、水啊、
我会提供水，会提供水，
just water
免费的
for free.
Thank you.
Thank you. Towadage.
Thank you, Mr. Chairman. Does he accept like client by appointment or by walk-in?
就是他这些客户可以直接走进去做呢，还是必须要打电话预约？
也可以直接走进去，面对所有的人。
Yes, walk-in is allowed, open to public, everyone.
How he's gonna manage the Saugus location, Square One location, and the Malden one, if it's working, if he's working into location?
他说：“你怎么同时管理这两个不同的地方？如果你要同时做的话。”
我同时做，我会四关万毛那里，我会让我朋友在那里，我呢到这边，如果这边有客人，我会来回，我开车来回走，我开车来回走。
I will appoint one of my friends to be in charge of the Square One location, and I will drive between two sites.
Thank you. That's it.
Very good. Eric Henry.
Thank you, Mr. Chair. Just a question or two. Currently, in your location at Square One Mall, do you have any employees?
在 Square One Mall 那个地方，你现在有任何雇员吗？雇了几个人
我现在雇了一个人，
？One employee.
Did he train this employee?
这个雇员是你自己招的吗？
是。
Yes.
Does the certificate that you obtained in California, I believe you said, does that in turn grant you to authorize or to license other people to perform acupressure?
他说你在加州拿到的那个证书，授予你的权利去教别人做 acupressure， 并且去为别人服务吗？
这个只要不用授权教，只要说你看一看就能看会了，只要看就能看会了，很简单。
Acupressure is not that hard, so it does not require any authorization.
I'm sorry, could you repeat that?
No, acupressure is not that hard to learn, so it doesn't really need any authorization.
But he has authorization, he has certification.
他说，虽然你说不用证，但你为什么又有证书呢？
我有证书，我那是学的按摩证书，我现在是做指压。
My certification is actually for massage, but I'm doing acupressure now.
Thank you.
Okay, does anyone else have any other questions? Michelle, did you have any?
No.
Very good. Is there anything else you'd like to add, gentlemen?
你还想说什么吗？
没有了，我这个指压主要是做足疗，做脚底指压，这是主要是做脚底。
Yeah, I just want to add that my acupressure is mostly performed on the feet. That's a major part of it.
Okay. I had one last question. I'm sorry, it just struck me. If you have one person in Saugus and you're expecting to have 4 or 5 in Malden, does that mean that your Malden location is 4 times as big?
他说，如果你在 Saugus 只有一个雇员，你现在在这边要雇4到5个雇员，这说明你在这边需要扩大4到5倍，是这样吗？
想，我有这个想法。
Yes, that's my plan.
Okay, thank you very much. Commissioner Miller, would you, if you guys are all set, if Commissioner Miller could come up and maybe address the most glaring confusion we have is, it seems that what the petition is going to do is acupressure, which isn't massage therapy, and sounds like you don't need state licensing to perform acupressure, whereas one does need state licensing for massage therapy.
Yes, Mr. Chairman.
Can you expand on that?
I'm going to do my best.
See if I follow
See if
it.
I can confuse this further. So we have a definition for licensed massage therapy salon within our ordinance, and obviously the key word here is licensed. And I'm not going to read you the whole definition, but the first sentence states, a place, office, clinic, or establishment licensed by the State Board of Health to offer massage services or acupuncture. So obviously in the process in dealing with this petitioner, there's been a little bit of a communication issue, and as he explained, our two languages look at the word massage differently, whereas this has been described to us as massage. We're now finding out it's not, it's actually acupressure. When you look at the state licensing requirements, 269 CMR, the first half of that definition is actually our definition word for word. The second half of that definition pretty much calls out all the things that do not require licensing, and specifically things that do not require a license to perform. What's mentioned is acupressure, and something else I heard the petitioner mention that is listed here is acupoints or meridians. So it appears that they do not need a license to do acupressure, and if they don't need a license to do acupressure, then they would not fall under the use as defined in our zoning, and they would need a special permit, would not need a special permit to do this.
And we need to be cautious that we don't approve a massage therapy location when that's not what their intention is, so that if they move out, someone else with a massage therapy business would be able to move in.
That's a solid point, and almost, I guess, the opposite side of that argument would be, does the board feel like they have to, or they should issue a special permit, because right now we do have the gray area, or more actually the disconnect between the state definition of what's licensed and our definition of what is massage. I feel that we should probably button that up on our end, now that we know that these things exist. But again, that's a decision for the board to make. I could almost argue it either way, I think.
Patrick, did that address your concern?
Yes, but I had a further question. I know that this is an issue that the Department of Public Health investigators have quite frequently with what you've described in the CMRs. What type of compliance checks that you're aware of that generally municipalities perform, or that Malden performs, in these types of establishments that don't require a license and otherwise don't require a special permit, where it doesn't fall under this portion of our ordinances?
That's a great question. Any special permit doesn't automatically induce any form of inspectional regularity. So there's no inspectional process that would be ignored because you guys do or do not issue a special permit. Again, I'm bordering on to the Board of Health regulations here, but I'm fairly confident the Board of Health does not inspect any business that doesn't have a state license that goes along with it.
Or a complaint.
Or a complaint, right. Obviously, they can inspect any business for any reason, but there would be no regular inspection required like there is with restaurants and bars and things like that, to the best of my knowledge. But
statewide or within Malden that you're aware of?
Statewide, I would assume where there is no licensing, right. There is no, I mean, if they're not getting a fee, they're not going to come look at it. So that I'd be convinced of.
Right.
Locally, Chris Webb would be the more of an expert on that than I am, but I don't think they would inspect it either.
Thank you.
Ken Antonucci.
Yeah, and Michelle, I'm not sure whether this is Nelson or you could answer this. I know we haven't gotten to the planning report and recommendation yet, but what's listed there, and you, Nelson, you mentioned that the first sentence is right out of the state. It's the same as the state definition?
This entire paragraph of our definition is right out of the state.
Okay, so that's...
It's the second half of the state paragraph we don't have.
Okay, so this, what you have in the planning recommendation
That's the definition in the current ordinance.
in the Malden ordinance.
Yes, this
and
is
it-
from the
and it-
city ordinance.
And it mirrors,
It
it is the
mirrors
same
the
as the
state.
state, except the state has an additional paragraph after this.
That's correct. And when this was put in 2013, the zoning was amended to create this definition in 2013.
Okay, because...
I don't know that second sentence was in there or it wasn't. I'm not 100% sure. I think we worked probably with,
Yeah, because in the second sentence of this, definition, it does indicate pressure,
right, but,
and, which maybe that's not just acupressure, but,
right, the second sentence that Nelson's referring to is a laundry list of things that aren't massage, and it calls out specific techniques in schools, and it calls out acupressure, and it calls out, the acupoints. It's very, very specific, the
yeah,
list.
I was looking it up, and it
Yeah.
does...
If I could,
Which I didn't have. I just received this from Nelson.
I would read this to you, but I honestly can't pronounce most of it.
Yeah, no, I looked it up online. too.
But to add to the confusion of this, you're correct. When we look at our definition, the word pressure is used at the beginning. Again, the petitioner was using the term massage. And then when we look at this, state licensing regulation, it does specifically use the term acupressure and meridians.
Right.
And that's two things I've heard them say, so.
And chi and all that. Yeah.
You wouldn't believe the stuff in here.
No,
yeah.
no.
I haven't heard of most of it.
I read it.
Any more questions for Mr.
No,
Miller?
but just to let you know, there is, and again, this might fall under Chris Webb, but there is a current proposal before the state legislature to regulate this, Reiki, all kinds of other energy-type things, so that might be coming down the line. But as of right now, it's not there.
Okay.
Mr. Chairman,
Anything else, Ken?
can I return this to Michelle in case you guys want to reference
Yes,
it?
we have one more question, which Mr. McCush may have for you.
I do, yes, thank you. So, just to clarify, if we do nothing or deny, they still have this use by right. But if we give them a licensed massage, the right for a licensed massage, then they leave, someone else can come in by right, have a licensed massage in that facility.
I think so. I don't think they need the permit for licensed massage, and I don't think they would exercise the permit for licensed massage. So any conditions you put on, they wouldn't necessarily need to comply with because they don't actually need an occupancy permit for licensed massage.
Or if we table it and take no action, they can still proceed.
I think they can, that's my opinion, but it's Nelson's the enforcement officer. Either he would issue an occupancy or he wouldn't. I would definitely suggest you take some action.
Yeah.
And either, allow withdrawal without prejudice or deny it, or whatever.
Yeah, without trying to make a recommendation to the board, I would say that knowing what we know now, they could open up tomorrow by right. Now, what happens if you provide a special permit to them for massage? I think Michelle is exactly right, that you would then be allowing that use even though they're not exercising it. So I would think you probably would want to stay away from that.
Yeah, and just thinking out loud, I was wondering if there was a way you could issue a special permit for something else. It is a pre-existing non-conforming building, but retail services doesn't require a special permit. You can sometimes need a special permit if you're making certain structural changes or alterations, which they're really not doing. And we didn't advertise under that section, so I don't think it's properly before you for a special permit for a pre-existing non-conforming conversion. So I don't think you could do that, but I was wondering if that would have been a possibility. At least then you could restrict the type of business. It would be it would be acupressure, it would be that type of business, you know, but.
Does that answer your question, Eric?
It does, yes, thank you.
Thank you. Ken Antonucci.
So if, what I'm hearing is that this isn't required, it can go in by right, and we should not issue a special permit at all because, for the massage therapy. But, so there's no sense, and I'm just being devil's advocate here, there's no sense in issuing a special permit limiting it just for acupressure because it's not required.
Right. I was trying to think if you could somehow issue the permit for acupressure under a different section, but you can't because we didn't advertise that way. I don't think that procedurally would be correct for you to do.
And also, the petitioner applied for, whether it was rightly or wrongly, for under the massage therapy.
Right, based on what he presented to the building inspector, he was advised to apply for the special permit.
Okay, thank you.
Okay, thank you. Okay, no other questions for you, Commissioner Miller. Thank you very much. Appreciate that. And
Thanks.
thanks again for attending tonight's meeting. Okay, so at this point, I'd like to ask if there's anyone that would like to speak in favor of this petition. Anyone to speak in favor?
I have one letter.
Seeing none,
I have one letter.
Michelle, do you have anything to read? Yes,
Yep,
please.
October 9th, 2019. It reads, "Good evening. I apologize for not being able to attend tonight's meeting in person. I'm traveling for work and am unable to attend. I write to you in support of the petition before you tonight to grant a special permit to 102 Main Street to allow a licensed massage therapist salon and neighborhood business. I capitalized licensed, that was written in all caps, licensed, because I believe the permit should only be granted once a Massachusetts Department of Public Health is submitted to the city, license is submitted to the city for verification. For this petition, I believe they meet all the criteria approval of the special permit, namely the proposed use is consistent with surrounding land uses, is not more detrimental to the neighborhood, nor is the traffic pattern more adversely impacted, and it is consistent with the intent of the common good. Although the petitioners reached out to me, we have been able to connect and communicate. However, based on the information present, I offer my support for the 102 Main Street petition. Thank you for your time and attention. Respectfully submitted, Peg Crow, Ward 1, City Council, 9 Hancock Street, Malden."
Okay, so you have nothing else to read?
No.
And I see no one else looking to speak in favor, so I declare that part of the hearing closed. Is there anyone that would like to speak in opposition to this petition? Anyone speak in opposition? Michelle, anything to read in opposition?
No.
No one to speak in opposition? Declare that part of the hearing closed. Michelle, can you take us through your staff report?
Yes, and I also want, if anybody wants to read the state definition for massage, I have that. I can pass that down. So the property is located at Bellrock Square. It's the site of a 3-story building. I've broken down what the use is. 98 Main Street is a apartment with 3 bedrooms. 102 Main Street's the subject of this petition, 987 square feet. 100 Main Street is the number for the 2nd and 3rd floors, and there are a total of 8 apartments with 1 bedroom each, so 4 on each floor. Petition is the proposed tenant and operator. We heard about the proposal, the front desk, the 4 massage reclining chairs, 3 massage beds separated by privacy screens. The existing closet will be converted to a laundry room. The existing office, storage room, and restroom will be maintained. I've itemized here the plans that were submitted. No changes are proposed to the other areas of the building or elevations. Subject premises are currently under general renovation pursuant to a building permit. The property is located in the neighborhood business zoning district. Licensed massage therapy use is allowed by special permit in this district. As I mentioned before, this zoning for that was created in 2013. Prior to that, the use was considered retail services. The definition in, the current definition in our ordinance is provided for licensed massage therapy salon. Prior retail sales, I've given you some information about some of the other occupancies in the past. I won't get into that, the history. The existing multifamily residential dwelling use up to 3 stories predates current regulations. It requires a special permit. It's considered pre-existing non-conforming. I will note it's not clear, sometime after 92, the bank offices were converted to the 9th residential dwelling unit. Didn't find much information on that. Direct abutters to the north are retail services and a single-family dwelling. To the south are retail services, a multifamily dwelling, and a 2-family dwelling. To the west, 2 3-family dwellings, and to the east, on the other side of Main Street, various businesses, general offices, retail sales, and services. Surrounding land uses are business, residential, and Bellrock Park. In terms of dimensional controls, the building on the subject property predates the current ordinance, grossly violates all dimensional controls except height, rear yard setback. The property is considered pre-existing non-conforming. The proposal maintains all existing violations, creates no new violations. This was reviewed under the requirements for licensed massage therapy salon in terms of dimensional and parking. Existing use of the property requires a total of 15 spaces. 4 spaces are required for the subject space. 11 spaces are for the multifamily dwelling use, 1 per bedroom, 1 space per bedroom. So the proposal maintains the same parking nonconformity, considered as a licensed massage therapy salon. It's the same requirements as the retail sales. Retail services have the same parking as well. There's no on-site parking. Properties considered pre-existing non-conforming. On-street parking is allowed and restricted by posted signage. In terms of traffic to impact, the proposal does not require traffic to impact nexus study under your rules and procedures of the Malden Planning Board. On that note, what I've been doing, now that we have the new rules and procedures in place, when a petition comes forward, I ask the building commissioner to give me something in writing for the file as to whether it requires a traffic study, and he's been doing that, so I do have a copy of that, his determination, so it does not require that. The findings listed here are to grant a special permit for licensed massage therapy. So 1 is that any creation or increase in dimensions of violations of dimensional controls of parking requirements will not be more detrimental to the neighborhood. 2, that the traffic and traffic patterns generated by the proposed use will not adversely impact any of the surrounding streets or create a traffic safety hazard. 3, the proposed use will not be more detrimental to the neighborhood. 4, the proposed use is not in conflict with surrounding land uses. And 5, the proposed use is in the common good, in the interest of the common good. So provided you could make those findings, and prior to the public hearing, my recommendation was that you grant a special permit subject to the following conditions. 1, submit a copy of the license from the State Department of Public Health for massage services. 2, all development shall be as per plans, except as modified by these conditions. 3, outside storage of any kind is prohibited. 4, no permanent dumpsters allowed on site. And 5, repair, replace sidewalks, driveways, perform necessary incidental work adjacent to the property to the satisfaction of the DPW director. At this point, that was my recommendation prior to the public hearing. At this point, I would recommend that you allow the petition to be withdrawn without prejudice. I don't recommend that you grant a special permit subject to those conditions. Based on information we've heard from the building commissioner and my own review of that, at this point, I don't believe a special permit is required. I don't believe that's the use that's being proposed.
Okay, Ken Antonucci.
Mr. Chairman, I'd like to make a motion to allow the petitioner to withdraw without prejudice.
Okay, Eric Henry.
Yes, before I second the motion, I just want to know, how do we get this in front of ordinance to make this correct? To add our, the second portion of the state finding to address businesses as the petitioner is presenting before us.
Yeah, that would need to be a petition to amend the zoning ordinance, to amend the definition. So the petition would need to be filed by the city council, and then it would be sent for public hearing by this board and the ordinance committee. So the city council amends the zoning. So would it be initiated just like any other amendment of the zoning?
Be one of our joint hearings.
Yes.
With the ordinance committee.
And what I would suggest, you know, or what I will do, because I have a list of amendments that we need to move forward. When a counselor is moving a petition forward and/or its ordinance chair asks me, are there any amendments, I give him the list. And that's, you know, if it's something urgent or something that one of the councils wants to move forward, they can just initiate it on their own. But usually what I try to do with my ongoing list is give it to, you know, when we're getting ready to schedule a hearing, or I know something's gonna be filed, request that that be filed as well, so that it'll get taken up at the next possible time.
Fair enough.
So Eric, you seconded,
Correct.
and you're all set, no other questions?
Correct.
Okay, Patrick doesn't need to. Do you understand what happened? Basically, it was determined that acupressure doesn't require a permit. Hey, why don't you come up to the podium?
所以他现在告诉你说，你现在做的这个指压按摩根本就不需要申请一个许可证，你就不需要申请许可证，你只要撤回你的许可证申请就好了。
So what we're suggesting is that you withdraw your petition without prejudice.
他就说你可以取消你的许可证申请，因为你根本就不需要，明白了吗？
这去 ，OK。
Okay? And just, so it's not being voted in favor, it's not being voted in opposition. Basically, it's being allowed to withdraw because it was determined tonight that you don't need one.
OK， 所以说他们现在既不会投支持，也不会投反对，是因为你根本就不需要这个许可证，你明白了吗？你根本就不需要许可。
那我可以开吗？我可以开业吗？
So may I open the store?
Yes.
Yes.
Yes, he still needs to go in and get the occupancy permit from the building department. So he'll go back to the office and he will, I don't know if they can do it under the same permit he's already applied for. He needs to apply or amend that. He needs the occupancy permit to open the business, but he doesn't have to go through this process.
OK， 所以你还是需要去申请那个空间使用的许可证，但你不用来申请这个许可。
OK。
Okay, if you have any questions, just call.
You can call me or come back into the office and they'll help you.
对，如果你有任何问题，你可以给他们打电话，或者回到市政府的办公室去找他们。
OK, thank you.
Thank you very much.
Thank you.
愿上帝与你们同在。
May God bless you.
Thank you.
Thank you.
So now
Same
you
to you.
vote on that.
Let's see, and before he slips out, I'd like to thank Commissioner Miller for coming the last couple of months.
You wanna
It's been
vote
very
on
it's been very helpful to have you here and help clarify some of these uncharted waters that we've found ourselves. But thank you very much, appreciate that. Okay, so Michelle.
This
you
is
can
on the
start
vote to
calling.
allow the withdrawal without prejudice. Ken Antonucci?
Yes.
Diane Shuha?
Yes.
Patrick Fitzgerald?
Yes.
Tawadich Geber Selassie?
Yes.
Patrick Hayes?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi?
Yes.
Chuck Iovan?
Yes, allowed to withdraw without prejudice. That's from Kenny to you. Okay, next item is status updates. Master Plan Steering Committee, no status update. Ken, can you give us an update on community preservation?
Yeah, we're just reviewing the applications for this funding cycle that was submitted prior to the 9/30 deadline. So we have several, and we're in the middle of reviewing those and updating our plan. Every year we have to update our plan and update and making some changes. So we're in the middle of that review and update process as well.
And when will that be finished, do you think? Any horizon?
I'd say within the next month. It's just some minor tweaking, month, maybe 2 months.
Very good, thank you. Michelle, can you give us the items 3 through 6? Updates on 3 through 6. Here, if you need that. Michelle.
3 is Housing Production Plan Advisory Committee. The group has not reconvened since the release of the housing needs assessment. And you all should have received a copy of that in the mail, a bound copy. So the group has not reconvened yet. You did hear tonight about some initiatives that the council's looking at to do with affordable housing, inclusionary zoning, and some of the recommendations that came out of the housing needs assessment that's still in the planning and processing stages. I'll give you updates as soon as I have them about those. Broadway Corridor Plan study is ongoing. They are collecting data. The initial phase of the study, there will be a community forum coming up. I don't have the date yet for that. I think it's the end of October, but I'll let you know when that is. Complete Streets Task Force reconvened this past month and prioritized on the existing list of projects that I've identified, prioritized new projects for this next round of funding. And Mayor's Working Group to Review Zoning Ordinances is meeting ongoing as well, looking at the inclusionary housing and also some commercial zoning. Those are the updates. Those 4 groups I sit on, participate in. One other thing I do want to mention under new business, attached to the agenda, you should have received copies of 2 notices of upcoming community outreach meetings for 2 of the marijuana establishments. So they're moving through the process of the Cannabis Licensing Commission that was established by the city. And so these two are moving to the next part of the process, which is to hold these community outreach meetings. So they're required to give notice to the planning board, so I'm giving you the notice. I received the notice. The meeting's on the same night in 2 different places. And if they move forward, my understanding, the next step in the process would be moving for a special permit. So that would go before the city council. This board would review and make recommendations. So if and when we get those in, I will be presenting those to you for your recommendations to make to the city council. So that's it. But I just wanted, that was attached to your agenda.
Very good, thank you. Next meeting is scheduled for November 13th. If no one has any questions or anything, is there a motion to adjourn? Second? All those in favor say aye. Motion carries. Happy Halloween, everyone.